Good morning. Now you can hear me. Good morning, everybody, and welcome. I was on mute, I didn't see. And welcome. This is going to be a short session. I think no more than 15 minutes, but I like it that way because otherwise it becomes too much of a hassle and I don't like doing it and you don't like listening to it and it's boring. Right, so this is a tax court judgment. It says SARS versus Taxpayer 3C, and maybe for those online joining, I just want to pause because I had advocates before say to me they don't understand the citations in the tax court. Tax court judgments are sanitized, right? So you don't know who the taxpayer is. It's also often very difficult to see if the case went on appeal, which tax court judgment was there. What's wrong? So this is a tax court judgment. Tax court judgments don't set a precedent. We look at them anyway because they are persuasive in value. You all know I am. Just a disclaimer, this training is intended for my staff and for those of you joining online, really just for interest's sake. All right. Judgment is very much procedural, unfortunately, or fortunately for some. I mean, this is the stuff that we work with daily. And it's important that we understand these rules because it deals with timing of pleadings. Now, I know that not all of you get to deal with matters that proceed to tax court, but the reality is that given as aggressive as SARS is nowadays, I'm seeing a hell of a lot more cases proceed to litigation, right? I just spoke to Mick in my office this morning to serve a notice to proceed with the litigation in the tax court because the matter wasn't settled. We didn't do this at the ADR, but the matter wasn't settled. And so things that used to be settled and resolved at objection stage or indeed at ADR stage, when you get to pre-litigation appeals, they don't anymore and they tend to go to litigation. So this is one of those matters. Right. This judgment was handed down Joburg Tax Court by Justice Marley, 12th of March. The issue was actually whether or not SARS ought to request condonation in the circumstance. And when you think about SARS being late, you can bet your hat. The first thing SARS is going to say, Virgin Mobile. It's completely misplaced. I don't know, often I wonder who these people are and whether they actually have degrees and qualifications, but anyway. Right, so the background to the dispute is the underlying dispute concerned an additional VAT assessment. So this is the main issue that this interlocutory related to, or procedural issue. Let's not get into that because that's next week's discussion, procedural interlocutory. But the underlying issue was VAT. The objection was partly allowed, taxpayer appealed, the matter went to ADR, and ADR was terminated by SARS in 2020, on December 2020. And on the 4th of December, within the 20 days, the taxpayer delivered its notice of intention to proceed because, by the way, for those of you who are not familiar with dispute resolution post-mediation or pre-litigation, before you enter into the litigation phase, if ADR proceedings are terminated, the ball is in your hands, in your court, if you will, if it's a tax court matter, to tell SARS that you're proceeding with the matter on appeal because that triggers SARS's obligation to deliver their pleadings. I've had many cases where taxpayers come to and said, I went to ADR and then they just terminated ADR and since then SARS have just been quiet. I said, yeah, they would be because you're supposed to take the next step. If you did nothing, it's a big problem. It's a major problem. It could result in you losing your case on finality just because you didn't take the next procedural step. But this taxpayer did, and the question is whether they did so properly. In this case, as they delivered their notice of intention, to proceed. Right. SARS then acknowledged that letter and said, okay, fine, because once you serve, or let me not say serve that notice, once you notify SARS of intention to proceed, they typically respond with a letter, say, yes, your matter has now been referred to the tax court litigation unit, right? And so SARS acknowledged that mail, and this is important, that SARS acknowledged that mail, right? Then, when you look at that date, on 10 December, SARS wrote that the matter is referred to litigation. SARS filed their Rule 31 statement 4 years later, on 4 December, right? That is slightly late, right? Yeah, given they've got 45 days from the date of your notice, that's just a little bit late, right? And no condonation application, nothing. They just deliver the Rule 31, right? And the taxpayer then, and this is crucial, and I think this is where SARS seems to just confuse Virgin Mobile with everything, or their advisors, it seems, right? Because the taxpayer got the notice and said, hang on, There's no condonation application here. I'm filing a Rule 56 notice, you're in default. Because absent the condonation application, it's not filed, right? And then SARS responded, and this is the issue in dispute, is whether or not SARS is required to request condonation. And the question on that in turn depends on when the SARS's 45-day period start to run. And that in turn is determined by this question. The mail that the taxpayer sent on the 4th of December 2020, was that a Rule 25(3)(b) notice of intention to proceed, or was it not? Right? Because what is crucial here is that the taxpayer had sent that notice, Nika, the one similar to the one that you prepared for me this morning. So they sent this notice to some official in SARS via email. Where are you supposed to send it? Tax court litigation at sars.gov.za, that's the prescribed address, right? And so the question was ultimately, okay, fine, if that email that was now not properly delivered, right, or at least so it seems, whether or not that was a proper notice, because if it was, then SARS is late, and then SARS must ask for condonation. The reliance on Virgin Mobile is entirely misplaced. It's quite laughable, quite frankly, but anyway. So SARS's case, of course, was that the 4 December 2020 email was not a valid Rule 25(3)(b) notice. Of course, they must say that, because they're 4 years late with a Rule 31 statement, right? So they have to get an out, and they said, no, that wasn't. And therefore, no proper notice has been delivered in the prescribed manner, and therefore their 45-day period never started to run. And Virgin Mobile meant that they don't need to do condonation. It makes no sense. The Virgin Mobile, like I said, I'm going to say it again because it's ridiculous. It's laughable. What happened in Virgin Mobile is SARS did not deliver a Rule 31 statement, and then the taxpayer said, here's a Rule 56 notice, and SARS remedied within the 15 days. And the court said, if SARS remedies within the 15 days, condonation is not required, right? That was what Virgin Mobile said. Here, SARS delivered and this is the point I made when Virgin Mobile came out. SARS did not deliver their Rule 31 and eventually delivered it, and then the taxpayer filed a Rule 56 notice. So, but you're supposed to ask for condonation. That's why I've said before, if SARS is late with a Rule 31 statement, think twice about whether you want to file a Rule 56 notice, because you're extending an olive branch, right? You're extending an olive branch by giving them that 15-day grace period. If you don't serve the Rule 56 notice, it doesn't mean they don't have to deliver Rule 31. What it does mean is that they have to ask for condonation. So you might want to, from a strategic dispute resolution point, I'm not saying always do that, but from a strategic dispute resolution point of view, I might want to look at this and say, so if this came to me, so no, I'm not going to serve a Rule 56 notice, I'm just going to drop tax court litigation, and might say, listen, when can we expect your Rule 31, guys? This is now very, very late. And if they then deliver, say, where's your condonation application? And the court in this case said, the taxpayer, well, let me put the taxpayer's case quickly. Taxpayer obviously says exactly the opposite. It says, no, it was a proper notice. SARS must ask for condonation. There's a drop in the signal, but anyway, SARS must ask for condonation. And they say that in substance, the service of the notice, even though it wasn't sent to tax court litigation at sars.gov.za, in substance, there was compliance with the requirements of that rule. Because what purpose does the rule serve? Because we look at endomeni, and we look at the constitutional era, we have to interpret rules in context and for purpose, right? And give effect to it in that manner. So what was the purpose, or what is the purpose of Rule 25 notice? It's to tell SARS that, listen, I'm actually going ahead. You're supposed to file a Rule 31 statement because I've told you that I'm going ahead. That's the point of the notice. That's why it's there. And they said that they complied in substance with the requirement, and that SARS therefore ought to ask for condonation. And the court agreed that the communication sent by the taxpayer was enough notice. In substance, there was compliance, because in particular, there was that mail from SARS where they responded and said, we acknowledge it, the matter is referred to tax court litigation unit. That's important. I think that's crucial, because the court said, well, clearly you knew, SARS, because you told them that you're aware, and so therefore, in substance, the purpose which the notice seeks to achieve was achieved, right? And so, although in the strict sense there wasn't compliance, it was in substance sufficient compliance, right? And there was clearly, if there was some compliance, there was a clear intention to proceed, and therefore, and Virgin Mobile, the court said, did not excuse SARS on the facts. There's nothing relevant about Virgin Mobile, really, right? Yes, it also has to do with the Rule 31, and it also has to do with condonation, but that doesn't mean that it's the same words. You must always go to Virgin Mobile. Somebody looked at Control F case law on 31 and condemnation, they came up with Virgin Mobile, I think. It seems to be the case. Right, or Google search maybe, I don't know. So, all right, so the point here is SARS had to apply for condemnation, but here's the thing that got me wondering, because the judgment is very thin, right, in terms of its portrayal of the facts and the circumstances to what caused this delay. And what they, as far as I can tell, the bloke in SARS who was allocated this case in tax court litigation unit, the reason he took 4 years is that he fell ill, right? And then he came back and then he carried on and he delivered the Rule 31 statement. That is as much as I can read from the judgment as to the facts. On its own, for me, that's not even close. Not 4 years, right? Not a 4-year delay. If you were sick or you were ill and it took 6 months to get another guy from SARS to take over the case, and you can explain that, sure, but just, I was sick for 3 years or 4 years. I understand that you're sick. I'm not saying that's not a serious thing. Of course, that's a serious thing, but the question is, ought SARS to be excused on the basis that they could wait 4 years on the back that one oak fell ill? I mean, that's not, in my mind, excusable. But then I don't know if there are other facts fleshed out in the papers before the court that explains it properly. But insofar as the judgment reads, the court just says condemnation ought to be applied for, 1, and 2, condemnation ought to be granted. Right. Of course, SARS had to ultimately pay the taxpayer's cost for having to bring this application, which is fair, right? Because SARS caused the delay. But in my mind, why SARS was excused for a 4-year delay, at least the reasons is not, or seems not to be properly canvassed in the judgment. Maybe it's in the papers, we won't know. Maybe if the taxpayer takes this on appeal, maybe we'll find out what was the reason. Because to get condemnation, you must look at whether or not condemnation will be in the interest of justice. Right? And one of the things the court must look at is the merits, etc., and the cause of the delay, and the reason for the delay, etc., to get condemnation. And condemnation will always come up in any Rule 56 application that you bring, right? Because, and this is what the taxpayer brought here, is a Rule 56 application, the SARS responded with a condemnation application. So it is important that you understand these procedures, right? So key insights in this judgment, I think, is the point I wanted to make is it seems that SARS will rely on Virgin Mobile whenever condemnation is up for debate, or whether they should ask for condemnation. Be careful, don't be intimidated by it. Virgin Mobile's reach is actually not that big. I mean, I've got another case that's set down in May. They're probably going to argue Virgin Mobile there as well, which is, again, going to be completely misplaced. So just be mindful. There are instances where SARS' reliance on Virgin Mobile, and indeed the taxpayers, because it cuts both ways, right, will be valid, but it seems as if they'll just raise it everywhere. Substantive compliance is enough. So what happened is, important is, so the taxpayer actually delivered a notice of an irregular step, or SARS delivered a notice of irregular step on the taxpayer for delivering the Rule 25 notice to the wrong email address. I think that was what it was. And SARS delivered a notice of irregular, or the tax, and vice versa, but they both withdrew it. I don't know why. I don't know why, because it seems to me like it might have been a valid point. But anyway, the point is the court held that both parties must carry their own costs in terms of the Rule 30 notices and applications, right? But two things: don't be intimidated by Virgin Mobile. Don't ignore it. Check whether or not SARS is right, but just be careful. They seem to be relying on it when they're not supposed to. And then substantive compliance with the rules is enough. Now, the issue, as you see here, this issue could have been avoided. This issue of whether or not SARS ought to ask for condemnation could have been avoided entirely if the taxpayer just delivered the Rule 25 notice properly, right? So now there's a court application you have to bring to deal with the fact that you didn't deliver it properly. Yes, you can get around it, but it's going to take you a court application to get it done, right? So ideally, right, and in fact always, deliver to the prescribed address. I call it the dispute address notice. In my book, it's in an annexure, right? And it's there for a reason. It's because when you deliver something, in terms of the tax code rules, there's prescribed delivery addresses to which both SARS and the taxpayer must deliver. And failure to deliver there might result in issues like this. Granted, they got around it, even though there wasn't compliance stricto sensu with the rule, but there was compliance. But you can avoid all of that, but just delivering to the prescribed address. Don't just send stuff anywhere, especially anything on Chapter 9, or most, yeah, in fact, everything. In a Chapter 9 dispute, that's objections, appeals, etc., they are prescribed addresses. And for the most part, it's not such a big a deal, because for the most part, the pre-litigation stuff, everything pretty much happens on e-filing, right? And I think most people know that. The issue is, as soon as you step outside of pre-litigation, outside of the e-filing system, then people start getting things wrong. For example, when you serve a Rule 32 statement, first, most people don't know what a Rule 32 statement is and that you're supposed to respond, or a Rule 25 notice that you're supposed to deliver. And those addresses, then it becomes a little bit of a manual process. And so unfortunately, if you get that wrong, it can be problematic.